to the court's decision that there was no such value in that photograph. The second requirement in Miller for a work to qualify as obscenity is whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. The applicable state law in this case is Florida Statute 784049, which defines a sexually explicit image as any image depicting nudity or depicting a person engaging in sexual conduct. We maintain that the photograph posted by the petitioner does fall into this category. By arguing the constitutionality of sexually explicit images, the counsel for the petitioner has also implied that they see the photo posted as sexually explicit as well. Finally, the third requirement for an act to qualify as obscene under Miller is that the work taken as a whole lacks serious literary, artistic, political, or scientific value. As I said earlier, neither the trial court nor the appeals court found that there was any such value in the photograph. States have the authority to regulate what is understood to be obscene or explicit in their own localities. We should give substantial deference to the opinions of the lower court, especially the fact that in the 6th District Court, the official opinion issued by the court stated they found the photograph to be depicting the victim in a suggestive manner. This differentiates this from a medical textbook and furthers the definition of furthers the claim that the photograph qualifies under the Miller definition of obscenity.
So is it your position that we should defer to a factual finding of the District Court of Appeal?
The factual finding, yes, Your Honor. In Miller, Miller dictated that the jury may measure the essential factual issues of prurient appeal and patent offensiveness by the standards that prevail in their foreign community. Miller also declared that when triers of fact are asked to determine whether the average person applying contemporary community standards would consider certain materials prurient, it would be unrealistic to require that the answer be based on some abstract formulation. This is still quoting from Miller. The adversary system, with lay jurors as the usual ultimate fact finders in criminal prosecutions, has historically permitted triers of fact to draw on the standards of their community. While we are reviewing this case de novo, because we do not have the facts in front of us, for example, we don't have the photograph in front of us to view, we should give substantial deference to the finding of the lower courts that it was explicit and it was obscene. The court made it very clear that the states have authority to regulate what is understood to be obscene in their districts, as they put it from Miller, which said, we now confine the permissible scope of such regulation to works which depict or describe sexual conduct. This depicted sexual conduct and was thus obscene, and so the state should have the right to regulate this. We contend that Florida Statute 784049 is constitutional under strict scrutiny and justly convicts the actions of the petitioner as obscene, fulfilling all three